where my impression of where the differences tend to lie, and personally, as obvious, the members of our court get on. I've never heard them in the conference room in 12 years in the most controversial cases. I say this over and over. I have never heard a voice raised in anger. I've never heard one member of the court say something insulting about another, not even as a joke. They really don't. We get on well. We get on well. But we have our differences. And I've tended to think those differences over time, and ours included, stem less from grand subject matters that command attention of the public and more from an approach to how you go about interpreting that Constitution. And there you've heard some of it, because I know that Justice Scalia is concerned and that if I use too much purpose or consequence and so forth. So now I want to raise the level of interest a little. And I'll just say that the normal question here, since you have criticized to a degree...
You're making me nervous. What are you building up to?
I want to say compared to what? Compared to what? Because if we go back to your favorite subject, history, and there I have a favorite case. I absolutely do. The favorite case was a case involving the ex post facto clause. And we had to decide whether it had a particular meaning, this or that. And for in a case in California, where California had passed a statute, and that statute made it criminalized a serious offense, but it criminalized it 25 years after the statute of limitations had expired. And they wanted to go back and prosecute that person for something they said he did more than 25 years earlier. And did the ex post facto clause apply? And I grant you it was a very difficult question. And I had to go into the history, which I don't always do. But well, it was an issue, and I went into it. Now, what it turned on...
Try it. You'll like it.
Yeah, I did. I did. This is what it turned on. It turned on, I believe, whether late 18th century, maybe early 19th century judge who talked about the ex post facto clause, Chase, and listed some conditions there, and really got them from Blackstone, who was an 18th century treatise writer, who in fact was describing a 17th century trial during just around the time of the British Civil Wars, which involved something that Parliament had done to the Earl of Clarendon and Bishop Atterbury. And what they had done was, to me, quite obscure. And I tried to look up every possible thing in sight, and all I can say, and I shouldn't admit this publicly, that if I got that right historically, it was a miracle. And because I am not a professional historian. And the questions are very often not just difficult from the point of view of open language, or even from the point of view of purpose and consequence, but from the point of view of history. So if we're going to decide all these things through history, let's have 9 historians, and let us not have 9 judges. And they won't get that right with Atterbury and Clarendon either, because I happen to notice in the history text, which I accidentally looked up, that they were in fact in disagreement. Well, you know, the historical approach also has disadvantages. It also isn't easy, and I believe too often it's removed from the roots of what is at issue, which is basically how a value embodied in that Constitution applies to a world which is a very complex world, and a country that has changed dramatically, but has managed to hold together with all these different views and different people, has held together because people do respect that document, and they do choose to decide their differences under law. And I think it's a good thing. In fact, to tell you the truth, and I shouldn't admit this, but I think it's a good thing when you have on a 9-member Supreme Court people who don't always see things exactly alike, and who do have different methods of interpretation and different approaches, because none of us have, well, you understand.
Well, the Chief Justice...
I can't even agree. I can't even agree with
you agree with that?
No, look, and I agree that you should have different people with different, who reach different results, but one would think that after 200 years, there would be some consensus on what we think we're doing when we interpret the Constitution. You know, I mean, these are wildly divergent views. Are we taking broad concepts such as equal protection and due process and asking, what should these concepts mean today? That's one view. Or, on the other hand, are we saying, what did these concepts mean when they were adopted? Now, as for the difficulty of figuring that out, the historical problem, yes, there is I'm not pretending that doing it by text and the original meaning of that text is perfect, that it's going to solve every problem. But it solves an awful lot of problems, especially the most controversial ones. It doesn't take a whole lot of history to figure out that nobody thought the Bill of Rights stopped a state from prohibiting abortion. Nobody thought that the Bill of Rights prohibited a state from criminalizing sodomy. Nobody thought that the Bill of Rights prohibited states from prohibiting assisted suicide. So many of the most controversial questions, it's a piece of cake to decide it. And it is not my burden to prove that originalism and this historical approach, what did the people do, what did they decide, it's not my burden to prove that it's perfect. It's just my burden to prove it's better than anything else. And the anything else is the other approach. It's up to the judges what equal protection should mean today, what due process should mean today. This is an immense amount of power in judges. And if you say that my approach should require historians, I cannot understand why your approach should require lawyers. I mean, what does a lawyer know about, whether there ought to be a right to an abortion or whether there ought to be a right to suicide? Let's put ethicists on the Supreme Court. Or what did I learn at Harvard Law School that gives me any capacity to decide these questions more properly than anybody else in the country?
You learned law. You learned law at Harvard Law School.
These aren't lawyers' questions. Once you reduce it to, what ought equal protection mean today? If you think that those words are empty bottles, let's be honest and say it's up to Congress to fill those empty bottles. That's the way the British do it. If they're empty bottles, and we're trying to figure out what does the current society think it ought to mean, whatever the Congress says, they know what the current society, I don't have any idea what the current society thinks. I don't want to know what the current society thinks.
Now, Justice Breyer, you've written in your book, Active Liberty, that certain decisions should kind of spark participation in democracy. So how do you square that with some of Justice Scalia's points, the abortion decisions, school vouchers?
School vouchers? You mean my dissent in school vouchers, which I wrote about. I wasn't on the court at the time Roe v. Wade was decided.
Or Stenberg, I guess.
I think I won't go into the abortion. But the vouchers, I think that's a very interesting case and actually quite difficult. Because it's absolutely true historically. It had to do with the meaning of the Establishment Clause. And that's tough. That's tough. I'm sorry, whether you're a historian or not a historian, that just isn't obvious.
I agree with that. It's the toughest.
And if you go back to what people probably were thinking, they probably thought it only applied against the federal government, and maybe the states would have established churches. And then what you see is an evolution really in the court's opinions. You see two evolutions taking place at once. One is that the country's changing. After the Civil War, at the time of the Constitution was written, probably there were maybe a handful of religions. By the time you get to today, and after the post-Civil War immigrations into the United States, we probably have 50 or 60 different religions. There's a tremendous degree of diversity that wasn't there before from a religious point of view. And I think what you see in the court's opinions over the 1950s, 60s, 70s, and so forth, is the court responding to that in light of what? Well, in light of a basic value that underlies that Establishment Clause. If you go back into the history of that clause, the religious clauses, they grow out of the civil wars in England. Read about those civil wars. My goodness, you talk about bad things today. I mean, the 17th century was just terrible.